Good morning, everyone. Welcome to the DC Criminal Code Reform Commission's online symposium. I'm Richard Schmeckel, the Executive Director of the CCRC, and I'm excited to have you join us this second final day of the symposium. Yesterday, the symposium opened with comments by Professor James Foreman, Jr., and a panel discussion on the history of criminal law changes in the district. We heard how in the 70s and 80s, district leaders, following the track of much of the rest of the country, turned to a tough on crime approach to respond to an increase in violence. There was an authorization of higher penalties, creating a new set of mandatory minimum sentences. Professor Foreman noted that at the time, alternatives to incarceration and other models for preventing crimes were not seriously considered or part of the conversation. And he contrasted that with today and the national trends in the country. He was hopeful. We also heard how the policy changes of that era continue today, perpetuated in the DC Criminal Code that is virtually unchanged, and in the men who remain behind bars for decades-long sentences. Notwithstanding the recent increase in homicides to levels in the district not seen since the early 2000s, today the overall violent crime and homicides too are actually less than half of the peak levels seen in the early to mid 90s. Yet even with the decrease in incarceration in recent years, the district maintains a per capita incarceration rate that is at the very top or higher than all other states. To give a sense of the scale of this, an analysis by the CJCC, the DC Criminal Justice Coordinating Council, found that in 2017, there was an average of 22,376 justice system involved individuals in the district on any given day. That's not arrestees. That's about a third of those 22,000 were incarcerated in jail or prison, with the rest in some form of supervision, pre or post trial. And yesterday, we also heard about how racialized incarceration is in the district. Virtually all those in the system are Black, over 90%, and male. Stark disparity with the district's overall population. Against that backdrop, this morning's first panel will address the assembly of the CCRC recommendations and discuss some of the single most impactful reform recommendations that were issued to the council and the mayor by the agency in March. But first, before I go on, I want to note that after this panel, I hope you'll stay on at 11:35. We're going to have the last panel of the symposium on the CCRC recommendations and looking in towards the future of criminal justice reform. And you'll have a chance to hear from Professor Paul Butler, author of Chokehold, Policing Black Men. Professor Butler's at Georgetown. You'll hear from Parissa Degani-Tofty, a progressive elected prosecutor from Arlington. Helene Flowers, a DC artist, writer, ambassador for Represent Justice, and Patrice Sultan, founder and executive director of the DC Justice Lab. That panel will be moderated by Mark Schindler, the Justice Policy Institute, and I really hope everybody will stay on for that beginning at 11:35. All right, to start, I want to discuss a little bit how the CCRC recommendations were assembled, and then invite on several guests who were involved in the process and discuss with them some of the more prominent recommendations. The CCRC, the Criminal Code Reform Commission, is a small independent agency in the district. It was created about just 4.5 years ago, and it's a research and advisory body. It doesn't make laws or regulations or enforce the laws. And the agency's work has focused on what is sometimes called substantive criminal law, the laws that state what a crime is and how it's punished. So the agency's recommendations don't address many criminal justice issues. For example, policing, which was the focus of the recent DC Police Reform Commission's recommendations. Those are not addressed. Crimes and punishments have been the focus of the CCRC's work and its recommendations. The process that the CCRC followed, I also want to emphasize, was not open-ended or unguided, and it didn't start with a blank slate to kind of ask fundamental questions about what the law should be. Rather, the agency's work was guided by its statute and worked to improve the current law. The CCRC statute gave specific goals for reform. These were matters of clarity, consistency, completeness, making sure the code articulates everything that must be proven, and proportionality, which obviously goes to sentencing. As noted on yesterday's panel, a tremendous amount of work is needed to update the code because while many of the district's criminal statutes have been updated over time piecemeal, there's never been a comprehensive review and reform of the district's criminal statutes since Congress first created them for the district in 1901, over a century. Today, in 2021, the district, it still has common offenses like assault or manslaughter, where the statutes themselves don't say anything about what has to be proven. There's just a penalty, and it's left for the courts to say what the law is, what constitutes the crime. Other offenses are so old that they use antiquated terminology. Again, something as common as the district's arson statute, refers to canal boats, refers to outhouses. It doesn't mention motor vehicles because in 1901, when that statute, again, basically got the same language, was written, obviously motor vehicles weren't even common. Statutorily authorized penalties also have never been comprehensively reviewed and examined to see what is out of sync. So these are the problems that we've kind of wrestled with in the DC criminal code. And it's obvious to those who've kind of looked to other states' laws. Some years back, Paul Robinson, who's a professor at the University of Pennsylvania, one of the leading scholars nationally on code reform, did a review nationwide of the district, federal criminal code in 50 states, and ranked them each on some objective kind of value neutral criteria. Things like, again, clarity, consistency, completeness. Were they even articulating what the law, what the crimes are? And in that ranking, and in penalties too, but when he looked at this, it was in terms of, were the penalties consistent? Whether they were high or low, were they kind of organized and had a logical approach? The results of this survey were grim for the district. We were ranked at 45 of 52 jurisdictions. So while there's a lot of work to be done, and that may be obvious to many, especially in comparison to other jurisdictions, finding a path forward has been challenging. Per the agency's statute, the CCRC went about this in several ways. One, it consulted with a 7-person statutorily specified advisory group. Many of these folks you'll hear from today. 2 were council appointees who are local law school professors. And then the statute also designated 1 individual each from several government entities: the Office of the Attorney General for DC, the U.S. Attorney for the District of Columbia, the Director of the Public Defender Service for the District of Columbia, the Deputy Mayor for Public Safety, and the chairperson of the Committee on the Judiciary and Public Safety. So those folks have been involved, again, by the statute in working with these recommendations and reviewing them. That advisory group met monthly for years. Again, we're about 4.5 years now into this process. And through the work of that group, they provided over 700 pages of written comments on the CCRC's draft work. The CCRC statute also directed it to look outside the district to get some different possibilities, to look at reforms in other jurisdictions, to look at changes recommended by the Model Penal Code, a national model for all criminal statutes, and to review best practices by experts in the field. The CCRC was also directed to do analysis of charging and sentencing and other statistics relevant to, particularly to penalty recommendations. So looking at what is actually going on now in the courts as compared to the law in the books. And again, I want to emphasize the root and the basis for the recommendations was current district law. So, looking and doing a lot of research as to what the statutes, but also the case law, what courts have ruled where there's a lot of ambiguities or incomplete statements of the law, what the courts have stepped in to say the law is. The agency did all this work, exhaustive legal scholarly research, working with court data too. We put together drafts, all of which were posted as the process has gone on. They've all been up on the agency's website, and the advisory group meetings were public too. So we had these discussions with a lot of back and forth with the advisory group. And in the end, came up with this very large package. The recommendations that were issued in March to the mayor and the council consist of really two documents. The first is statutory text for new offenses and penalties, what we refer to as the Revised Criminal Code, or the RCC. And this statutory text, what is being proposed for the new statement of offenses and penalties, follows a model that again was developed in the Model Penal Code and has been adopted by most states for really over 50 years, right? So this is a structure for the code that is well accepted in other jurisdictions. It does some fundamentally different things than the current code. It has what we call a general part that provides definitions for new terms. It talks about defenses for the first time, codifies in the law what constitutes a valid offense. It also puts forward a standard penalty classification scheme. And maybe we'll get to talking a bit more about that later with some of the panelists. The other main piece of the recommended statutory language is what we call the special part. So we have a general part addressing matters that kind of cut across many offenses. And then we have the special part that identifies all the particular statutes, assault, homicide, burglary, you name it, and goes through each one and revises the language in a kind of much more consistent manner. The whole thing, the statutory text is nearly 200 pages in length, and it addresses all the crimes, or nearly all the crimes, over 97% of what's in current use and being prosecuted in recent years. But there was another part of what the CCRC did. And I just briefly note, it put together kind of a reference book, a legal commentary that describes how in each of these cases for murder, for burglary, for each offense, how it changes current district law, which again was kind of the baseline from which the reforms took place. That commentary is huge. Again, it's a reference book. It's nearly 2,000 pages long. But that's what we came together with from this multi-year effort, working with the advisory group. And on March 24th, the 5 voting members of that 7-member advisory group voted unanimously, 5-0, to approve the submission of those recommendations to the council and mayor for further consideration. So again, the CCRC it's an advisory body. This now moves forward into a legislative phase, hopefully this fall. And I'd also note, the unanimous approval that the agency received for its recommendations doesn't mean that the advisory group members agreed on every single issue. Certainly a number of issues I think some we'll talk about this morning. There are different perspectives. But I also want to emphasize there was a tremendous amount of agreement and also an interest in moving these recommendations forward so that they can have a broader public and legislative consideration. Okay, with that background on kind of how these recommendations were assembled, I want to welcome and briefly introduce the 4 panelists we have on this morning. who were part of the advisory group's efforts and who will be joining me to talk about some of the most impactful reforms. First up, we have Don Brayman. Don is an associate professor of law at the George Washington Law School. He's also a senior social scientist in the lab at DC, a unit within the Office of the City Administrator. Don does research on criminal law, trust in government, science communication. He's done large-scale randomized studies on public perceptions of crimes and public safety, policing, guns. He teaches in these areas too. Among his publications is the book, Doing Time on the Outside, Incarceration and Family Life in Urban America. So welcome, Don. Next, we have Laura Henkins, and Laura is the General Counsel for the Public Defender Service for the District of Columbia. She provides counsel to the PDS executive team. Prior to becoming the General Counsel, though, Laura was Special Counsel to the Director for about 16 years, where she was the point person to monitor and comment on legislation before the DC Council, criminal justice, juvenile justice, mental health issues, you name it. She worked on over 50 bills in that time period. And I'd also note she's served on the committee responsible for drafting the district's pattern criminal jury instructions, an important stopgap, kind of a way to, in practice in the courts, communicate what the law is in the absence of statutes that are themselves complete and accessible. So welcome, Laura. We also have this morning Alana Suttenberg joining. Alana serves as Special Counsel for Legislative Affairs at the U.S. Attorney's Office for the District of Columbia. She's worked at the USAODC for nearly a decade, and prior to serving in this role as Special Counsel, she worked as a senior AUSA prosecuting domestic violence and sex crimes committed against both children and adults. Before that, she was law clerk to the Honorable Royce Lamberth on the U.S. District Court for the District of Columbia. And I note Alana, too, has kind of done some of this other work helping to develop the criminal jury instructions. Again, how to communicate the current state of law to jurors who have to make hard decisions in the courtroom. Last, we have Elizabeth Weiser joining us. Liz is the Deputy Attorney General in charge of the Office of the Attorney General's Public Safety Division. Previously, she headed that division's juvenile section, leading a team of OAG prosecutors who handled the district's juvenile crime cases. Prior to joining OAG, Liz's career included stints as an attorney in private practice. She clerked in U.S. District Court for the district. So we're happy to have Liz as well. And just before I get going, I want to note, so Don, Laura, and Ilana were all at the table as designated advisory group members. Don named directly by the council, Laura tapped by the PDS director, Ilana by the U.S. Attorney for DC, and Liz with the OAG has been kind of helping that office throughout in reviewing policy matters raised by the recommendations. So our panelists have a lot of familiarity with the recommendations. I hope that today we can dive into some of those recommendations, just the tip of the iceberg, as it were. So I want to start, and I'll give a little short overview of the topic. I want to start by talking about mandatory minimum sentences, which I think is going to show some of the major changes that the code reform recommendations would bring. So to start, what are mandatory minimums under current district law? So under current district law, there are really dozens of ways a person can get a mandatory minimum sentence. Among others, there are mandatory minimum sentences for first-degree murder, carjacking, committing a wide variety of drug or other violent crimes when a person possesses a firearm or a weapon during that crime. The weapon doesn't have to be used or brandished, just possessed. Those are some of the most common mandatory minimums, but There are others too, and the length of those mandatory minimums really varies. On the one hand extreme, we have life without release for murder of a law enforcement officer, down to, some of the lower ones are, like a year for mandatory minimum for theft of an item with 2 prior theft convictions. Okay. So we have a wide range of kind of the penalties that are involved in these mandatory minimums. I would also note that under current law, there are no mandatory minimums for a number of other very serious offenses, among the most serious, a number of sex crimes, human trafficking, kidnapping. Those actually don't have mandatory minimums. So this is kind of the current state of the law. And before kind of turning to the panel, I want to note that, there's obviously been a big national conversation about the continued use of mandatory minimums. A number of organizations from the Judicial Conference of the United States, the American Law Institute, which puts together the Model Penal Code, American Bar Association, as well as some other kind of nearby regional groups. The District Task Force on Jails and Justice noted that they were calling for an end to mandatory minimums. And nearby in Virginia, the Virginia State Crime Commission very recently also recommended repeal of all of that state's mandatory minimums. We've heard about it in the news. The Biden administration has made a number of comments about mandatory minimums in the past. And I want to note that the organizations that have been calling for repeal of mandatory minimums are often pointing to research about that they actually fail to promote uniformity in punishment, which was one of the underlying rationales in the first place for mandatory minimums. And they also note that it is a mechanism for really shifting control over sentencing from courts to prosecutors, and really affects the plea bargaining process. So those are some of the issues in play, and I'm gonna turn it over to the panelists to see what they think and just ask you all, what are your thoughts on the underlying rationale, what's viable and what's not for mandatory minimums, and should they be repealed in the district? And I'll open it up to whoever wants to go first.
Apparently that's me. Oh, Alana, it was about to be you. You want to go first?
I'm happy to. First, I just wanted to say thank you for having this, and I really just wanted to say that it's a pleasure to be here. We appreciate you convening this panel and this symposium and giving everyone a chance to share and learn about this. So thank you for hosting this. Generally, I did just want to talk about the CCRC and say that the U.S. Attorney's Office really does support many of the goals of the CCRC. And we voted in favor of the recommendations moving forward for further consideration by the council and mayor. And we do believe that they do a lot to improve the clarity and proportionality of the criminal code. And I think that's really important, an important project that we were pleased to be a part of. We do have some concerns with some of the recommendations as drafted, as Richard and others are aware. Most of our biggest concerns focus on the most violent crimes, child sex abuse, murder, other violent crimes, and ensuring that those who should be held accountable can be, and the realities of certain resource constraints of both our office and Superior Court. As to the question that you actually just posed in terms of mandatory minimums, the U.S. Attorney's Office, of course, is part of the Department of Justice, and our position is consistent with the broader department's position. Attorney General Merrick Garland, stated at his confirmation hearing, as President Biden has suggested, we should consider the elimination of mandatory minimums so that we once again give authority to trial judges to make determinations based on all of the sentencing factors that judges normally apply, granting them the ability to do justice in individual cases. So our position is consistent with the broader department's position.
Laura, did you want to jump in?
Just to clap my hands. Yes, thank you. I want to thank the CCRC and current staff and former staff for their incredible work over the past 4.5 years. the Public Defender Service supports code reform. We also don't agree with everything. It doesn't go far enough in many respects, but it is a significant, it would represent a significant improvement over our current system. I want to just sort of say a quick word, a little bit more about the general need for code reform by talking about the crime of threats, and then sort of use that to sort of move into to answer the question about mandatory minimums. So to talk about threats, we have two different statutes in our criminal code that criminalizes the exact same conduct of threatening someone with bodily harm. And the Court of Appeals has ruled, yep, two different statutes, exact same conduct, and the which one gets charged is completely up to the prosecutor. For adults, that means it's completely up to the U.S. Attorney's Office. For that same conduct, for the same conduct of threatening someone with harm, the U.S. Attorney's Office can charge a violation of the misdemeanor threat statute, which carries 6 months in prison, or they can charge a violation of the felony threat statute, which carries 20 years in prison. But threats is also really useful for understanding the importance of code reform because the Court of Appeals only recently decided what constitutes the crime of threats. The statute, as it was passed by the legislature, and I didn't actually go look at the history, would not surprise me if it's part of that 1901 set, meaning the legislature was Congress, and they didn't define what mental state was required for threats. So the Court of Appeals had to define it. This is what Richard was explaining to us. So one case decided in 1982 said that to be convicted of threats, the prosecution had to prove only that you voluntarily said the words, that you sort of intended to utter the words, and that an ordinary hearer would understand from the context that the words were threatening. Another case decided in 1983 said that to be convicted of threats, the prosecution had to prove that you intended your words to be a threat. 34 years of the court going back and forth over what mental state was required for the crime, where the line between innocent and guilty should be drawn. 34 years of federal prosecutors in the district charging and getting convictions against hundreds, if not thousands of people. 34 years it took. The DC Court of Appeals finally decided that a person had to act to be convicted of threats. A person had to act with the purpose to threaten or with the knowledge that their words would be perceived as a threat. And that sort of gap in legislative silence and the convictions that can happen in that space, in that time, is really a perfect example, and only one of many that we could give about why the district desperately needs code reform. So the code reform package would change a lot about our criminal code. It looks like huge change, but it's only because our current system is so broken and serves us so poorly. So taking mandatory minimums, for instance, I am thrilled to hear that the U.S. Attorney's Office, which is part of the Department of Justice, is now for eliminating mandatory minimums. We do not need them in the district, particularly where we have a voluntary sentencing guidelines system that judges largely follow, which actually does a lot towards reducing the goal of unwarranted disparity and even guides judges in many cases towards imposing prison time, which might be some people's argument for keeping mandatory minimums. The reasons why prosecutors, apparently not in this moment, usually like mandatory minimums is because, as Richard alluded to, it gives them a tremendous amount of power in the charging decisions, like that threats example of, do I give 6 months or do I charge a 20-year offense? Particularly as Premal Daria spoke to yesterday on the panel, where there's a ton of overlap between offenses and sort of what can be charged. When prosecutors have mandatory minimums that they can charge, it's incredibly coercive, and they are driving the system when they have that kind of power. If you care about DC statehood, home rule, local control, and accountability, we should be against mandatory minimums, and the Public Defender Service is.
All right. Thank you, Laura. Others, Dawn.
I see that Liz was taken unmuting, so I'll let her go.
Thanks, Don. Richard, thanks so much for including the Office of the Attorney General in this panel discussion. And I echo the sentiments of Laura and Alana about the importance of this effort and really the Herculean efforts that the Commission has undergone to get this package to the Council. And the Attorney General is thrilled that it has advanced, and we're looking forward to many of the recommendations becoming law in the District of Columbia. You know, we come from a unique perspective as the locally elected prosecutor who essentially has no authority over any adult criminal crime in the district, right? That we only have authority to prosecute a very small number of adult misdemeanor offenses. But of course, the Attorney General takes very seriously his role of being the chief law enforcement officer in the district, who must, of course, consider public safety and the community's desires when we talk about reform and changing legislation. And so with that lens in mind, we have been analyzing the recommendations of the Commission and engaging in conversations to come to what we think is an excellent package of reform for the Council to consider. And like Laura and Alana, there are some aspects of it that we do not completely agree with, but most of it we do. So we're excited that it's moving forward. With that said, with regard to mandatory minimums, you know, I think the Attorney General is of the view that judicial officers should be able to exercise their discretion. And he is in favor of getting rid of mandatory minimum sentencing and support this aspect of the code reform that's been proposed. I will say candidly that there is one group of cases that the Office of the Attorney General has concern about, and that is cases involving folks that are arrested for driving while intoxicated. We do have mandatory minimums for those offenses. And there are members of our community that feel very strongly that mandatory minimums should remain in place with regard to those offenses. You know, nationally, Mothers Against Drunk Driving is an advocacy group that, as we all know, has strong feelings about this. And also locally, our Vision Zero coalition has strong views about traffic safety and pedestrian related deaths with regard to vehicular criminal offenses. And so that's the one area that I would say we may disagree with, but I know that the Commission has not yet addressed specifically the driving while intoxicated statutes. And so we're waiting to engage in that conversation about that topic. Thanks.
I want to thank everybody at the CCRC for all the work that they've been doing too. This was an amazing experience to be part of this reform effort. And as a law professor, I'm delighted to be able to go from a position where I use the district as an example of how not to draft statutes to one where I can hopefully in the near future talk about how you should draft statutes. I think it's really, it's going to be a fundamental shift in how we think about drafting our criminal code, and it's going to help us be a lot more rational and thoughtful about everything we're doing going forward. So I'm really happy about that. I'm also happy that we're starting on something where there's broad agreement. I think there actually was, and I think the other panelists have talked about this, that there actually is broad agreement on a lot of what the CCRC has proposed and is recommending. And you know, we disagree on some things, but I think it's great to see this ability to find overlapping consensus and to move forward on all of those areas where there is really substantial agreement. I think it's probably true in the case of mandatory minimums for a lot of reasons. It's relatively arbitrary in terms of its coverage. It's it's deprecated by nearly every major independent advisory body in the country. It makes a hash of proportionality, and it's totally unsupported by social science with respect to enhances in public safety. And so I think moving away from the kind of uninformed, well, as Richard was describing, as the panelists yesterday described, the period during which mandatory minimums were proposed and passed that was not informed by evidence, to one where we really are thinking very clearly about the evidence is something that I think bodes well for the district, and that I'm really, really pleased to see.
Great. Thank you all. I'm actually, there's so much we can talk about, and so to keep things moving a little bit, I'd actually like to move forward. I'm sure.
But some of us have responses, but that's okay.
I'm sure we do, and I'm sure you will find a way to work them in. But I want to move on to look at a second major component, the recommendations. And this is the CCRC recommendation on second look expansion. So the CCRC recommendation is to expand the availability of this procedure, the district's second look procedure, which allows convicted persons to petition the court for a change to their sentence. And under the CCRC's recommendation, there would be no age limitation as to the age of the person when they committed the crime. The CCRC recommendation doesn't do anything else to change the current second look procedure. It just lifts the requirement that is there under current law that the person had to have been under 25 at the time of this offense. A little bit more kind of background to fill this out for those listening. So under current district law, a person who committed an offense before they turn 25 can petition the court to reduce their sentence, but they have to do so, they have to at least serve 15 years in incarceration before that petition. The court then has to hold a hearing, and the second look statute right now provides a number of specified factors, like the recommendation of the U.S. attorney, statements by the victim, the defendant's record while incarcerated. A number of other items are kind of in the statute that the court has to consider. And then whatever the court decides, it has to issue a written opinion explaining its reasons for either granting or denying the motion. Now, ever since the district eliminated parole about 2 decades ago, the second look procedure has kind of filled, as it's come to into existence, has filled a gap, but it's been focused on young offenders. It's been the only mechanism to provide an opportunity to kind of reevaluate at a much later point in time that initial sentence to see whether continued incarceration is warranted for persons serving these long sentences, again, at least 15 years, at least. In general, the other mechanisms that exist under district law for modifying a sentence, at a later point in time, reviewing it, there aren't any kind of in the way that many jurisdictions have parole, right? That kind of discretionary review. But there is a up to a 15% reduction in a sentence that a person can get, so-called good time credit, as determined by the Bureau of Prisons for that person's behavior while they were incarcerated. There's also a compassionate release mechanism for sick and elderly. It's played a huge role in kind of how prisons and the DCGL have in this last year during COVID responded. But those good time credits and the compassionate release, that's kind of it for possible later sentence review and reduction under current law. Again, the district has what's been labeled truth in sentencing laws that was part of a kind of a bargain struck at the federal level about 2 decades ago. And under that, again, what sentence is given initially sticks, right? It can be reduced up to 15%, or there's compassionate release mechanisms. But unlike many jurisdictions across the country, there isn't another chance besides this second look procedure. So that's the conversation kind of about like how at a later point in time, there's this review after a person has served at least 15 years. And I want to recognize, again, there've been a number of organizations recently calling for the use of second look, but the one that the commission, the CCRC, really focused on is the model penal code. Again, there was a recent update by this body of experts, national body on the sentencing provisions. And part of that was their recommendation nationally to that all jurisdictions should have a second look procedure in place. It's also been the topic of, again, the district task force on jails and justice. And I also want to know, because I think it's definitely part of the conversation, is the district just recently changed this, right? Like it recently expanded eligibility for this procedure from being under 18 at the time of the offense to those who are under 25. But there was a lot of discussion about this, right? In fairly recent discussion. So many who been attuned to these policy choices and changes in law have been part of that conversation just the last year or two. And this would be a further change, just to be clear, to remove any requirement as to the age of the person when they committed the offense. So that kind of background about kind of what we're talking about here. I want to turn to you all again and ask, what are your thoughts on the continued rationale for either not having a second look procedure available to all persons, or what are the factors that concern you about this recommendation as well?
Okay, this time I am going first.
Somebody's gonna jump in. Good.
So I want to start by saying, and you alluded to this in your opening remarks, Richard, in a couple of ways. One, sort of talking about how many people are justice involved every day in the district. You also sort of talked about our current crime rate and compared it a little bit to 2000s, but really then compared it to the early 90s, which is when I arrived in DC, moved to DC. I grew up in Baltimore City, but I moved to DC in 1992 to become a public defender. And DC could still be called Chocolate City then. And you could be forgiven for not particularly sort of recognizing or sort of seeing how Black men were churned through the criminal justice system, because the city looks so much like that. The city's changed a lot, but we have this little time capsule on Indiana Avenue. If you miss the old days, you can go into Superior Court and it looks exactly the same. It's probably one part of the city that hasn't changed in who we are sending through the system. We lock up people for far too long, too many people, the same community. One of PDS's main goals for code reform is to ensure that the system creates meaningful opportunities for decarceration and provides alternatives to entry into the criminal legal system. The system needs safety valves. It needs fewer on-ramps into the system and more off-ramps out of the system to allow for justice and mercy. The prosecutors, particularly the federal prosecutors who are not accountable to DC residents, should not be the gatekeeper for all of the mercy and non-criminal outcomes that are possible. Judges should also have statutes and authority that allow them to be gatekeepers. Second Look is a powerful safety valve. It recognizes that rehabilitation is possible. More, it incentivizes rehabilitation, programming, and good behavior during incarceration. Further, while aging out of criminal behavior might be more dramatic for the 18-year-old going into the 33-year-old, it is still true for the 25-year-old who becomes a 40-year-old. For years, we in the district have been locking up too many people for far too long. The maximum prison sentences proposed as part of code reform are still too high. Second Look provides only that, a second look. It not only allows for the person convicted of the crime to grow and change perspective, it allows society to grow and change perspectives. For example, the way we now think differently about crack versus powder, or how we think that maybe it was racist to label children super predators. Of course, Second Look should be expanded. To do otherwise is to deny the possibility that everyone is capable of change, including ourselves.
Others want to weigh in?
I'll take a stab at it. I agree with everything that Laura just said. I think that particularly this notion that aging out of crime stops only for folks that are under 24 just doesn't make sense, right? Like but people age out of crime. We know that statistically. I'm sure Professor Brahman can talk all about the stats about how folks age out of crime. And again, if we're talking about wanting to give judges discretion on the front end with abolishing mandatory minimum sentences, we should give them the discretion on the back end to reconsider sentences. And as Laura also said, it's a tough process to get through second look, right? Like you have to go through the process, and if you are denied the first time, you have to wait a period of years before trying the second time, and then again, if you're denied, you have to wait another period of time for the third try, and then you lose your shot, right? Like 3 strikes and you don't even get consideration after that. And so there are structures put in place in the act that will protect the community's interest, will be mindful of public safety, but will give folks who are incarcerated for long periods of time an opportunity to show rehabilitation and opportunity for judges to be merciful in situations where it's appropriate. I also will say that, one of the things that we are mindful of is the impact of the IRA process on victims, right? And one of the things that we know is that there are many victims who want an opportunity to speak with the person who harmed them in a restorative justice sort of conference. And our office has been, sort of on the forefront nationally of providing restorative justice opportunities for kids in the delinquency system. And we have just recently asked for more funding from the council so that we could provide this opportunity for folks that are in the IRA process. Because one of the things that we're learning, right, is that victims oftentimes want extrajudicial opportunities to deal with the harm that happened to them. And it seems like a perfect structure that could help in IRA cases, right? For victims will have a chance to speak to their perpetrator if they choose to in a structured environment that would help hopefully promote healing and will aid in their decision making about their views about whether the person should be released earlier or not. And so, we agree with the premise of IRA. We think it's an important opportunity and that judges should have the discretion to consider these opportunities going forward.
And I can weigh in too. We are continuously reviewing and assessing what constitutes best practices in the field of sentencing reform. I do want to note, though, that given the gravity of the relief in these motions, the early release of a defendant who's committed what's typically a very serious and violent offense, we do want to ensure that the U.S. Attorney's Office will have sufficient resources to thoroughly investigate and address these motions and ascertain what our position will be and contact the victim, which is sometimes difficult to do, to involve them in the process to the extent possible, and then resources where appropriate for Superior Court to litigate these important motions. As you've noted, and as everyone knows, this would significantly expand second look review from current law, which, as everybody here knows, was recently expanded by the council. I did obtain some recent BOP numbers on data on how many people this would affect. According to the most recent data I have, there's about 460 people who are eligible under the recently expanded version of IRA 3.0 or Second Look Act, and a universal second look after 15 years would allow an additional 335 people who are currently incarcerated at BOP to move for their release. Of course, those numbers fluctuate as people are released for other reasons or time served, or more people get to 15 years. So that was just a recent snapshot. And then, of course, we also do want to ensure that there are sufficient supports available for victims as they go through this process, and supports to support reentry efforts for people who are released, to ensure that they're able to successfully transition back to the community, and that we can ensure public safety following the return.
I will just second what Alana just said, and I really want to point out that we're having a great deal of overlap here again, which I love. This is supported by a lot of research. It just turns out that everyone, and the most recent research, I don't want to pick on prosecutors, but the most recent research has focused on prosecutors' overestimation of the the effects of criminal history on future criminal conduct, and underestimating the effects of aging on reductions in future criminal conduct, especially in the context of violent offenses. That's not to pick on prosecutors. They're really just showing that that's consistent with everybody else in society. We all do that. And there's really great research showing no effect on public safety. So for these extensive sentences that are beyond 10 years. And I really appreciate the concern about having real reentry programs for people to help reduce serious violent crimes. There's a huge study coming out of Chicago showing that programs that are like the district's Office of Neighborhood Safety and Engagement Pathways program, in Chicago they call it a READY program, substantially reduce gun violence and mortality, both for the people who are involved in those programs and for the people who are associated with the offenses that they've committed, but are not incarcerated, typically victims. And so I really think that moving the dollars that we're currently spending, locking up, as Laura has pointed out, vastly disproportionately Black and brown men to these types of programs that really invest in finding employment and housing for our residents and building their human capacities is very, very promising for the district. And I think I'm just so pleased that this is becoming an option for us. It means that the United States might actually join many other countries that have been doing this all along. And so I think this is a great opportunity for the district.
Fabulous. Thank you all. I think again, as we kind of near the end of our hour, I want to quickly jump forward a bit and talk about one last recommendation, which is a different in nature. And that's the recommendation to expand defendants' access to a jury trial. Initially, the way the recommendation works, defendants would have a right to a jury trial for several additional misdemeanors than they currently do. And then the recommendation is that 3 years after the revised criminal code were to go into effect, defendants would have a right to a jury trial for all misdemeanor charges carrying any imprisonment time. So that's, be clear, like that's what the recommendation is. Now, it may be a surprise to some that you don't always have a right to a jury, right? I think that is a common misperception. Under the Sixth Amendment to the Constitution, there is a right to a jury, but only for serious crimes, as the Supreme Court has interpreted that constitutional provision. And the case law there presumes that penalties that are less than 6 months are, again, presumptively not serious, and therefore, under the Constitution, states and the district can choose not to provide juries to defendants. Now, in the district, until 1993, district law went kind of below that constitutional requirement. It extended a right to ask for a jury whenever a defendant faced a charge carrying a maximum penalty of more than 90 days. So it was a 90-day line. But as part of, again, the crime wave, that peaked, in the 90s, that's when there was this decision made to move the line for when defendants haven't access to a jury, to move it basically up to that constitutional limit, 180 days. And the thought at the time, the testimony of the council, was that this would free up resources to provide more resources to focus on felonies and streamline the dispositions for misdemeanors. So it was a decision kind of struck in the middle of the 90s and the crime wave. And last thing I want to say, because running to the end of time, is look, most states, about 38, have provisions that allow access to juries for any misdemeanor carrying jail time. So the district's one of the other dozen or so jurisdictions that has a different approach. And actually there are only kind of 9, like the district, that kind of go up to that constitutional requirement, don't do anything more. So again, the recommendation is to expand access to juries. This has been under consideration, was raised recently by a DC Court of Appeals judge who said that this could help elevate the public's trust and confidence that government's concerned with protecting individual rights and ensuring justice in the courtroom rather than efficient processing. It's kind of an extraordinary statement that the Court of Appeals rarely makes such statements. But in the last few minutes that we've got left, I'm going to turn to y'all and see what thoughts you have and concerns about how this shift would affect criminal justice in the district.
I'm happy to
So
jump
can I
in.
start?
Oh, go ahead.
Alana, I'm going to
Either way.
jump in first.
Go ahead, Liz.
I'll be quick. I think we are at this moment, right, where we are considering police reform and criminal justice reform, and we are doing very important things in the district to provide off-ramps for folks that are involved in misdemeanor conduct in the district instead of prosecution, right? We're doing a really good job with that in the juvenile sphere, and we are also beginning to do it more and more in the adult sphere, both at the U.S. Attorney's Office, at the court, with the mental health court and the drug court, and some of the things that the Office of the Attorney General is doing. And so I think we are reducing the number of folks that are coming into the system being charged with misdemeanors, right? And so the concern of the high crime era of the 90s and the Misdemeanor Streamlining Act and the impetus to do it because for the sake of efficiency, I don't think is a fair argument anymore, right? Especially when you're considering that we need to consider the liberty interests of an individual and their right to have a jury trial if they're facing any period of time of incarceration. Because the fact is that a day of incarceration or 2 days of incarceration is going to make somebody lose their job, could make them lose their children. There are all sorts of collateral impacts to even a day in jail. And so we should be mindful of that when we're making decisions about who should be entitled to a jury trial. And so the Office of the Attorney General's position is we want liberty interests to be at the top of consideration, and we think it's appropriate for there to be jury trials for all misdemeanors where jail time is a penalty.
Great. We're almost at 11:30, but 1 or 2 last short comments. Ilana, did you want to chime in?
Sure. So from our perspective, this is really mostly a resource constraint issue and something that I think needs to be carefully considered in consultation with Superior Court. The U.S. Attorney's Office declines to charge or no papers almost half the cases presented to us by arrest or citation every year, a number that's been dropping in recent years as a percentage. And we offer diversion opportunities, and we recently expanded diversion opportunities for many of the people charged. And the reality is for jury trials, they take more resources, they take longer to try, they'll require more members of the community to participate as jurors. And felony cases, particularly detained felony cases, tend to be prioritized by the courts. And so in misdemeanor cases, our concern is that this will, as a result, delay justice for victims, for defendants, as the misdemeanor cases that have a jury demand take longer to get to trial. And so we're concerned about it in that respect.
I know we're out of time. Really quickly, it is important to talk about the right of the defendant to a jury and to be judged by one's peers, but it is also our right to serve on jurors. We in the district actually have limited opportunities to participate in our democracy compared to the rest of the country. This is an area where the U.S. Attorney's Office has manipulated the system from the day misdemeanor streamlining went into effect, that they break down felonies in order to avoid jury trials, in order to deprive us the opportunity, district residents, of the opportunity to take part in that part of democracy and directly take part. We can buy this system on the cheap. We can do it, but we got to stop calling it a justice system if that's what our priority is going to be. we can just call it like the racist punishment system or something like that. If really what our top thing is going to be is, ooh, it's expensive to actually dispense justice. That's my position.
I'll just add maybe for that reason and other reasons, jury trials increase public trust in government and in the justice system, especially for citizens who are not only, but especially for participants who are participating in juries. And so I think it is a fundamentally important public function that brings the residents of the district into and builds better trust in the criminal justice system. So I'll just add that to it.
Fabulous. Thank you. Thank you all. We are at time. We have to wrap this panel conversation up. Thank you, Don, Laura, Alana, Liz, for giving your time. We're going to switch over here in just a couple minutes. Anybody who is coming on, please hold on. Those who are already on, we're going to take a brief pause here at 11:35. In just a few minutes, we're going to switch over panels. So you'll see a screen come up. But I hope you'll stay on. We've got Professor Paul Butler, we've got of Georgetown, we've got Parissa Degani-Tofty, elected prosecutor from Arlington, Colleen Flowers, artist and writer from DC, we've got Patrice Sullivan. Really going to be a fabulous panel here with Mark Schindler moderating. Please stay on just a few minutes, bide with us. Again, thank you all. Thank you all so much.